Hi, good afternoon, everyone. This is Rajiv S. Khanna from immigration.com, the law offices of Rajiv S. Khanna PC. Welcome to our bi weekly, every other Thursday, community conference call. Today is November 17th. As you would have heard when you logged in, this is not an attorney client privilege telephone call. This is merely guidance as best as we can. It doesn't substitute for a one-on-one consultation. Okay, that said, I want to begin first with the questions that I've marked as frequently asked questions. The first one in that genre is a 212D as in Doctor 3 waiver. What is a 212D3 waiver? A 212D3 waiver is a waiver from any problem in your background. Pretty much anything that has happened that causes you not to be able to get a non-immigrant visa. This doesn't apply to green cards, only non-immigrant visa. You can apply for the visa, and if you get denied, you can then at the consulate apply for a 212D3 waiver and make the point to the government that the cause for disqualification was inadvertent or is excusable. There are various things they look at. And a 212D3 waiver basically allows you to obtain a non-immigrant visa to come to the United States. Ramesh has a question. He had a B1, B2 visa. It was cancelled and he was deported from New York. Can I reinstate my cancelled visa? Well, first of all, if you were refused entry and you were formally excluded from entering the United States, there's a 5-year bar from coming back. And that bar can be waived by 212D3 if you get some kind of a non-immigrant visa. But the fact that you came on B1, B2 and it was cancelled makes me wonder what the grounds were. So this can be a fairly serious problem. They don't normally just cancel the B1, B2 visa. There must have been some reasons for that. So without knowing the reasons in detail, it's difficult for us to counsel you. But 212D3 waivers in general are available to people who have any kind of disqualification and they want to come into the United States on a non-immigrant visa. For example, if you got an H-1 visa or an L-1 visa, you could potentially apply for 212D3 waiver. It's not certain that you will get it, but that is the only choice pretty much you have for non-immigrant visa entry. Press *5 if you have a follow-up question on this. No new questions, please. *5 if you have a follow-up question. Okay, it doesn't look like there's a follow-up question. Folks, just to let you know that tomorrow the I-140 rule, the so-called I-140 rule, final rule will be published. It will become effective within 60 days. So government has published the final, well, they have put out the final rule. I'll review it. I'll have it up hopefully over the weekend or by Monday for everybody to take a look at what my comments are. I'll point out the main provisions. I expect they'll be about the same as I have. I'm pointing out on my screen in my blog. If you go to my blog and you scroll through, you'll see the rule. In here, it has been already commented upon. So once again, the I-140, the so-called I-140 rule will be published tomorrow and it will become effective after 60 days, which is a good thing for us. Okay, let me go on to our next frequently asked question. Functional managers on L1A. This is also a very important area of the law. L1A is a very good visa. It can lead to a green card through EB1C category, which takes less than a year or so to get your green card. L1A requires that an intra-company transferee, So a company has a sister company, let's say in Europe or India, and another company in USA, and they are related sisters, or they are one is the parent of the other, and they want to transfer either an executive level or a managerial level employee. They would come through L1A visa. L1A visas are of two kinds. Let me rephrase that, not two kinds, but L1A can be approached through two different directions. Sometimes if you are supervising other professionals, for example, if you are a software delivery manager, you are supervising 7 software engineers, it's quite obvious that you could probably qualify under L1A as long as your activity in the actual production of the good software or service consulting is minimal and you just manage the effort. So L1A, simple L1A is for people managers, professional managers. Okay. Once again, for people who are just logging in, let me repeat that the I-140, the so-called I-140 rule will be published tomorrow. We have an advanced copy. I'll make some comments, but on my blog, we have comments on the proposed rule. Chances are it will be pretty much the same. So if you go to my blog and read the comments, we have it all covered, but I should be able to get it out to you by Monday. Okay, so back to L1A, managing professionals. And if you're not managing professionals, sometimes you can be managing or be in charge of a critical or important function of the organization. For example, we had a case in which a professional level employee or a senior level employee was in charge of providing what they call is the costing or the pricing of services. So any project that the company was bidding on, he was responsible for providing what costs we want to bid under. And now this company is a huge company, 20, 30,000 employees. He's not supervising anybody. But there's no doubt that what he's doing is so important that it is definitely an executive or managerial level job. So the question here from Anik, Anil K. Kapu is, his wife is getting a blanket L1A. She'll be directing business leaders like business heads to implement L&D and organizational development initiatives. Yeah, these are all good signs. She's directly reporting to the vice president of global HR organization, who is next step to the CEO. She'll work closely with business heads. I think it looks like even without the reportees, there is a healthy chance she can get an L1A as a functional manager. And there's nothing wrong with functional manager role. We do it all the time. Does the case get weaker? Not necessarily. It depends upon the case. It looks like a doable case from what you're describing, Anil. What would be some of the common roles and responsibilities a consular officer looks for in a functional manager? That's very difficult to predict. But the fact that she's so close to the top of the hierarchy is a good sign, especially if the company is large. Would her experience be enough to file for L1A? There is really no limit on how much experience you must have, and that information you have is correct. So it looks like it can be a case for an EB1A functional manager. Any questions on this? Star 5. No new questions, please. Any questions on this? Press star 5. Okay. This is another one of a very important frequently asked questions that comes up quite often. So I've got my green card through employment and I left the company, let's say the next day or the next month or 6 months from when I got the green card. Is it going to be a problem when I apply for my naturalization? Are they going to say, USCIS is going to say that, well, it doesn't look like you wanted to join the job on a permanent basis? So the answer is probably not. It's probably not going to be a problem. The history of this requirement that you must be willing to join the job on a permanent basis is based upon those situations when the entire green card process used to take just a few months. Now it takes so long. I think USCIS would be hard pressed to make a case if an employee leaves too early. What is too early, we don't know. But the law is this. If we were to strictly go by the law, first of all, permanent does not mean forever. Permanent means indefinite. So if I join your company or I get a green card through your company and I have the intention to remain only for 5 years, after which I want to leave, on the date I got the green card, that was my intention. I really don't have a permanent intention because I have a date in mind or a year in mind. If, on the other hand, I had the intention to stay forever and ever and ever, and 3 months after I got my green card, or even 3 days after I got my green card, I got a great offer from another company. I joined them, would I lose my green card? I don't think so. Because on the date you got your green card approval, you had the intention to stay indefinitely. Now that is the strictest interpretation. There is a whole lot more going on here. Normally, like in this case, what has happened is he had an IT profile. He resigned from the company, took some time off, joined company B. I was still with company B, but different job profile. But you see, you got your green card in mid of October 2011, and you took time off only in Feb 2012. I don't think you're going to have any problem. Unless in October you had already decided to leave this employer. Then it could be a little trickier. But as long as the date you got your green card approval, it was your intention to stay indefinitely. Now remember, I used the word intention. Intention is a state of mind. It can only be investigated and determined through your statements and through the circumstances surrounding your particular case. So if you were already sending out resumes and looking for a job, government could raise a stink about it. I personally don't think it'll be that easy for the government to try to come after somebody's green card on the basis of having left too early any longer, especially because of AC-21, which allows job portability. *5 if you have a follow-up questions, folks. Any follow-up questions on this issue, press *5. For some people who are just logging in, I want to remind everybody that the I-140 rule, which had been pending for many months, has been finalized. It will come out tomorrow, published tomorrow. Within 60 days, it will be active. My blog has all the comments on the proposed rule. Normally, the proposed rule and final rule are not that far apart. You can read that until I publish the final version. I should have that on my blog by Monday. So you can read that again. People who are still logging in, I remind people that I-140 final rule is out. I should have a blog entry up by Monday. So go to immigration.com and see my blogs. I can show you on the screen where they are. It's right here on the top where it says Rajiv's blog, and also there's a link on the right-hand side panel of immigration.com. Okay, so I take it there are no questions on leaving the employer. Let's get started now. I just want to make sure I covered all the frequently asked questions. Yes, I did. So let's get started now on the questions that are posted that were not frequently asked. So one question is from Anesu, who is processing a family-based green card through his mom as an unmarried son of a US citizen. Can I adjust status if I'm out of status? The answer is, if you are out of status, I think even the kindest interpretation of law, which is section 245K, for people who are not immediate relatives of US citizens. There is an exemption for people who are immediate relatives of US citizens. But if you are out of status for 180 days or more, even under the most benevolent exceptions, I don't think there's anything we can do or suggest for you. Even if you have issues of health issues or issues that stop you from traveling, I don't see how you can find an exception in the law. I don't know for sure. You can discuss it with a local lawyer, have them go through your case, but my instinct is, or my knowledge says, there is no way for us to get you an exemption from adjustment of status. And the problem is, if you are unlawfully present, then you could be subject to 3-year or 10-year bar if you leave USA. So it's a difficult situation. You have any follow-up questions? *5. No new questions. Follow-up, *5. Okay, let's go on to the next question, which is about H-1. Is it legal to give or receive money while both giver and receiver, I guess, are on H-1B? So the answer is, what does giving money mean? If you are loaning money and not doing it as a business, sure, you can loan money. But if you are taking work from them and converting that somehow to your business and they are converting it to their business, then of course it is illegal to do so. Can this affect your EAD or green card process? Yes. Once you get your EAD, then you are fine. Let me check my tweets 1 second. Twitter, nobody's on Twitter. Okay. So once you get your EAD, of course, you can do anything in addition to your green card job. But if you are working without authorization, working illegally, it can have an impact on your adjustment of status, your H-1, and even your green card if you are trying to conceal it from the government. Does IRS share data with USCIS? I don't know the answer to that question. I believe they do. Will these kind of transactions ever come under review or scrutiny from USCIS? They can. USCIS can question them if they find out about it. Can they find out about it? Well, that's a difficult question for me to answer. One, as an officer of the court, I am not going to assist anybody in breaking the law. At the same time, it's also your right to know what the limits of your legal liability in any situation are. All I can do is suggest to you, please discuss your situation with a lawyer through a one-on-one consultation. Go over exactly what you are planning. Many times there are legal ways to do the same thing. *5 if you have a question. *5 if you have a follow-up question on this. Madhusudanan has a spelling mistake in his I-140 approval. Normally, a spelling mistake should not be a problem. And yes, it can be corrected at the I-485 stage. What you can do is you can have your employer call and confirm if the name change has occurred, but normally the name change does not get done with just a phone call. It requires at least a written request from your lawyers. And the government will not change anything on the I-140 unless the error or the deficiency is on their part. If the error or deficiency is on the part of the forms package that your lawyer uses, which cuts off the last alphabet in a long name, then they're not going to correct it, but they might correct it at the I-485 stage. Normally, again, Madhusudanan, just because there's a minor error in the name should not take away your priority date or your right to use that approval, the I-140 approval, beneficially. And you should be able to beneficially use your priority date. I don't think the spelling mistake should cause a problem. It might cause some questions, but ultimately you are the same guy, just a alphabet missing. Now, do you need to start a fresh green card process? Not for this reason. Not for the reason of a consonant missing in your name. It could be if you have other issues, for example, you are not covered by AC-21, then you might have to start your green card all over again. Again, there are people still logging in. I remind you folks that the I-140 rule, which had been pending for many months, has now been finalized and will be published tomorrow. I'll have on my blog information about the new rule. Information about the proposed rule is already there on my blogs, and normally the proposed rule and the final rule are pretty close to each other. Okay. Now, Madhusudanan, do you have any question? If you're on the phone, press *5. Press *5. Okay. Next question is really beyond my expertise, but I can tell you the general rules. This is from Kasha Basha, who says, can parents who are permanent residents apply for Medicaid coverage? See, what I understand, and I could be wrong about this, I am not a benefits lawyer. I believe that Medicaid is a state-run program. It's run by the state. So the rules could be different in different states. Normally, if a green card holder takes what is referred to as means-tested benefits. Means-tested benefits are those which are given based upon somebody's income. So if they take means-tested benefits, they can have problems with their green card, as well as the person who sponsored them can be asked to pay up if they take any benefits. So since I don't know exactly what the Medicaid system in that particular state is, you may have to talk with local lawyers in that state. I think you'll have to talk with the benefits lawyers, figure out if it's a means-tested benefit. Some benefits are given to everyone, no matter what their income is. If it is that kind of a benefit, you are okay. But if it is a means-tested benefit, it can probably lead to those two consequences. *5 if you have a question. Follow-up question on this *5. Okay. Next one is New Hope 13, Canadian citizen on H-1B, going through PERM through a future employer under EB2, born in non-English speaking country. So what do I do about my translations? It's usually a good idea to get fresh translations. I think you could use your same translations, but 25 years ago, I don't know. I would rather have you do fresh translations. There's no law against, there's no expiration date on these things, but USCIS can usually insist on something more recent. Remember one thing, translations can be done by anybody as long as they know both languages. So let's say I speak French and I know French and I speak English. There's a French document, I can translate it and put a couple of lines in the back end saying, I, Rajiv as Khanna, do hereby certify that I am well conversant or well proficient or proficient in both the English and the French languages, and that I have translated the foregoing document accurately, truly, and to the best of my ability. Signed, dated, name, and address. Anybody can do that. It doesn't have to come from any official source. Your friends can do that. I would discourage you to use family members. That's not a good idea. But any friend can translate and put these lines, and that will be acceptable. *5 if you have a follow-up question on this. No new questions. *5 for a follow-up question. Okay. Next question is from Samir. Filed I-130 6 years ago. It was denied, and I don't know why the I-130 was denied. So you filed a Freedom of Information Act request, but now the government is saying that you need a written authorization for the individual permitting disclosure and identity and all that. Well, I think what you can do is, I'm trying to think of, I don't know what the RFE is. You could run it by a local lawyer and show them what should be done. But because you filed the I-130, you can tell the government, I am only looking for information about my petition. My petition. I'm not looking for information about a third party. So they are wrong in requiring more authority since it's your case. So if you write back to them or go to your congressman's office, that could be another thing you could do. Go to your local congressman's office and say, they are giving me this hassle. I don't understand what the problem is. I'm only asking for I-130 that I filed. *5 if you have a follow-up question on this. Adele, I think you could have a problem because you're in and out of USA a lot and you have filed as a non-resident. So if you file taxes as a non-resident, that does become a problem. Because now, is this a rebuttable issue? I don't know. We'll have to research it. But if you file, for example, as a non-resident alien, government can consider that to be declaration that you are no longer in the United States, and that could lead for an indefinite amount of time, and that could lead to loss of green card. So I would say get yourself a lawyer, have them research this issue. I don't know the answer off the top of my head what the consequences of filing as non-resident are, but I know that we always discourage people from doing that and tell them not to do that. So I've never run into this situation before, therefore I don't know the answer off the top of my head. Okay, next question is, now this is from Sarah AV or Sarah VAV. The question is, if I have a chain of entities between my employer and my end client on an H-1B, and one or two people in the chain changed, one or two entities changed, vendor or sub-vendor or prime vendor, do I have to do an H-1B amendment? So I do not know the answer to this question. It should be decided by a lawyer who's looked at the contract between the entity that's being changed, both up and down the chain, comparison with the entity that was before then. As long as the responsibilities and control have not changed amongst the parties, and you said the job is the same, work location is the same, I would guess, that's my guess, if everything remains the same, I don't see why you have to do an amendment. Location is the same, nothing has changed substantially. But then again, government can take the position that if one of the vendors or vendors changes, we want to take a look at the case again. I do not know the answer to this question. Look, amendments are not very expensive. I think it costs about $500 filing fees for an amendment without extension. So why not just do it? Wouldn't that be easier? As a practical matter, I would just do the amendment. But if you want to be aggressive, I can certainly argue that an amendment should not be needed. *5 if you have a follow-up question. *5. Okay. Next question is from Winter Soldier. Currently on H-1B, working in a client place in USA, you got a visa revocation email. I'm assuming that was because of the DUI issue. You have an LCA going on. It was certified on October 3rd. If I-94 exit date is passed, actually your facts are not very clear. If you are on the phone, press *5. Winter Soldier, if you are on the phone, press *5. Okay, good. You are here. Hi, good afternoon.
Hi, this is
Yeah, you are Winter Soldier.
like I
So hang on.
yes.
Let me ask you a few questions. Let's straighten out what your
Yep.
situation is. So currently, is your I-94 expired?
No, like I just checked with CBP and they have removed that port of exit. But previously it was submitted as November 3rd, and I contacted them and without any reason they just removed it. And they asked me to check it. So now it's empty. So I guess that port of exit is fine now. But still that email revocation
Okay,
still
okay, okay.
exists. Like when I checked with the Chennai
Hang on, back up a little bit. So your I-94, as it was issued, was expiring on November 3rd.
yes, when I checked on November 3rd, it says port of exit is November 3rd.
Okay, so your I-94 was expiring. I'm trying to pin you down to that answer. Your I-94 was expiring on November 3rd.
Yeah. Previously it was empty. Once I get the email and then I check the history, it was updated as November 3rd.
Okay.
And then I contacted CBP and then they said like they have removed it, but they didn't say any any reason for it.
Okay. So
But current
this
status is like
this
past,
whole thing is
port of exit
hang
is
on. This whole thing is very odd. Now, do you have a DUI conviction?
no, I did not have anything.
So who sent you the visa revocation email from consulate?
I got the same direct email from Chennai Consulate itself from ChennaiAFraud.com. I got the same email.
Is it based upon some fraud that was committed at the consulate?
That's what I just checked with the Chennai Consulate, but they didn't say any reason on it.
Okay.
They are saying the same again. They sent the same email.
Okay. Now the problem is I really don't know what is going on. This is very odd behavior on part of the government agencies. Normally, when government wants to revoke something, they should be sending you a notice by mail. Okay?
Yeah.
Email notices are not sent out. I'm not sure whether this is fraud or somebody just pulling your leg. I'm not sure. Number one. Number two, for CBP to first make a mistake on your I-94, then remove it altogether doesn't make sense. I think the first thing you need to do is you don't have any fraud in your background or anything you're worried about in your background, do you?
Yeah, there is no fraud on it. Yep.
Okay, so if there's no fraud, at least go talk with the CBP at the airport or one of their sub offices and figure out why don't you have your I-94. First thing to do is get your I-94.
Okay.
From the date your I-94 expires, 180 days will get you 3-year bar, 365 days will get you 10-year bar. So you want to keep an eye on the I-94 expiration once you've nailed it down. Okay? Now this whole situation is very odd. I don't understand what is going on. So obviously your wife's status depends upon yours. If something is wrong with your status, then her status goes south as well. First, we need to figure out what is going on with your case. So you should talk with the CBP, find out why your I-94 was removed. I would strongly encourage you to also figure out, maybe talk with a lawyer, get a consultation, show them the email, show them the rest of your paperwork after you've talked with the CBP, and see if there is something that can make sense. This whole thing doesn't make sense. Normally, consulates revoke visas for DUIs. So if somebody comes on a 3-year H-1, second year they get convicted of a DUI, consulate will send a mail saying, we are revoking your visa, however, your I-94 is still good, you can continue working. But if you travel outside, you have to go for a new visa. Okay? So that's the normal procedure. I have never known consulates to revoke such an important thing as a visa through an email. That doesn't make sense to me.
Is it any reason with LCA and the amendment process? Because LCA has certified on October 3rd.
They should still notify you. Consulate doesn't get involved with LCAs. They should still notify you via US mail, not via email. Okay?
Okay.
So let's get together with CBP, find out what's going on, then call your lawyers and get together with them. Okay?
Sure. Thank you. Thanks.
You're welcome. Good luck. That's very odd. Okay. Next one is from Rishali. H-1B expires 2017. Company has applied for prevailing wage in early August, hoping to receive it by December. So February, March we file. Is it possible to get approved by end of September? It is possible. It can happen in 5-6 months. You never know. You get 45 days of recapture. Yes, of course. So see, here is what happens, Vishali. So let's say that there's a gap between when the new H1 can start based upon the earlier green card filing and the old H1 is expiring. You just have to leave USA for a few days or a few weeks and then basically get an H1 that starts from the date that you can come back. So if you are late by 3 months, you'll be outside USA for 3 months. It's not like you lose the right to get an H1 extension. Quota is not an issue. Getting H1 done is not an issue. The only problem is you might have some interruption in work. Star 5, if you have a follow-up question on this. Star 5. Okay. Next is Kupu Durai Swami. Got I-140 approval in 1999. Can I still use the priority date? And the answer is yes. Yes. Unless it was revoked by the USCIS, there is no expiration date on I-140s. You should be able to, Shankar, use that 1999 priority date. Star 5, if you have a question. Star 5, follow-up question. Okay. Brahma says, by the way, guys, spell my name right. It's R-A-J-I-V. And my name is Rajiv S. Khanna. There are actually 2 lawyers other than myself on the East Coast with the same name as mine, but they don't have the name middle initial S. So I always use S. R-A-J-I-V is my first name, Rajiv S. Khanna. So I am Brahma, came to USA in July on L2, then transferred to H1 visa. I'm now working on H1, good till 2019. I've got an I-140 also. I don't have a degree from USA. Can I go to Canada or Mexico for stamping? Yes, you can. They may have questions or they may not be able to do it if they can't verify the degree or they want to verify the degree. Because see, you've never gotten an H1 visa. So they could make an issue of that. By the way, there are some new people still logging in. Just to remind you guys, the so-called I-140 rule has been finalized. It will be published tomorrow. I'll have it in detail up on my blog, I think by Monday or so. Okay, but the old proposed rule is there. You can find it in my blog. It's pretty much going to be the same thing. Okay, so can I go to Canada or Mexico for stamping? Yes, you can. I'm planning to go to India with my 5-month-old kid, US citizen. Can I leave my wife here on H4? If the visit is short, you can leave your wife. But if the visit becomes 7 months, 8 months, 9 months, it becomes uncertain what her status here is. Because the government takes the position if you're gone for a short duration, then the H4 can stay here. Couple of months I think would be okay. But if it proceeds to 4, 5, 6 months, maybe she should go back and join you in India. Star 5, if you have a question, star 5. Okay. Last question is, this is from an employer. Monica posted this. I have a quick question. We sent an offer letter for OPT, but the employee never joined us. Is this a problem? Well, first of all, it must be the old times because OPT now requires also, what is that, Form 981? So unless you file that, there really is nothing here that the employee can use under the current rules. But it is normally a good idea. I like to keep the record clean. Just shoot off a letter to USCIS, to the school, as well as to SEVIP, which is for the students, branch of ICE. Just send a letter copy to everybody that they never joined. You did provide the employment letter. You just want the record to be complete. It's always a good idea to do that. Any follow-up question on this star 5? Okay, we have time, about 20 minutes for new questions. Let's get started. Star 5, anyone has any question? Two questions, two hands up, three hands up. Only 3 guys? 4, oh, 1, 2, 3, 4, 5. 5 people have questions, 6 people have questions, 7 people have questions. Okay, let me see how many I can get to. I'll go in the order that you guys logged in. Okay. First, I'll go to our own neighborhood, Virginia. Go ahead, Virginia. Virginia. I can hear you, Virginia, if you speak up. Last 4 digits of your phone number are 6445. I can hear you. Okay. Let's go to Connecticut. Connecticut, speak up. Are you guys not hearing me? I wonder what's going on. Say hello. Connecticut. Okay, let me try to unmute everybody for a second. For some odd reason, let me try another method. Let's say we go to the 703 area code first. Can you hear me, Virginia? Can you hear me?
Hello. Yeah. Hello.
Okay, good. I think I was doing something. Go ahead, please.
Hi, I'm Akansh. Hi, I'm Aswati. Actually, I came to USA on 22nd of July this year, 2016, on a tourist visa. And after coming here, I met a boy, and I fall in love with him. And we are planning to get married here. So after completing, like after 90 days, we completed, and we went for a marriage license. So we got a marriage license, and we are applying for planning a date for marriage as well. So I would like to know what is the process for because since my fiance would be a U.S. citizen. So what is the procedure?
The first thing that I would worry about is to make sure that you did not have a preconceived intention to get married when you entered USA. It's very important.
No, I met him here.
That's very good. Because if it was something that developed after you entered USA, you should be okay. What you want to do is you want to look at Form I-130. Form I-130, which is the form that your husband will file for you. And then you have to look at Form I-485. Okay, which is what you would file for yourself, which would then convert you from B to green card status. That's called adjustment of status. So Form I-485 gets you adjustment of status. There's a whole bunch of other forms, I-765 for work authorization, I-131 for travel authorization. So get all these forms, download them, read them through, and follow the instructions on the forms. You should be okay.
Okay. So what is the time involvement for me to get an EAD or a green card application?
EAD usually within 90 days, green card usually within a year, but you'll get it conditional for 2 years. At the end of 2 years, 90 days before the second anniversary, you'll have to ask for, you'll file Form I-751.
So after I have done my got my marriage license. Now we are proceeding to get a marriage date. So in between, do I need to go through the procedures of filling these forms and submitting it, or I can get a marriage date and I get married and then we'll
You
start
get
doing it.
married. You
How do
get
you need?
married first, but download the forms and make sure you understand what is needed.
Okay.
You need your birth certificate and
Okay.
things like that. Yeah. Just be prepared to file
Yeah.
the forms. Fill
Okay.
them out, read them through, and be ready to file them. You can't file them until you get married.
Okay.
All right.
So first step would be to get
That
married
is correct, ma'am.
and then file. Yeah, and then get all the forms in place with the birth certificates and
That
everything
is
in
correct.
place.
Yes, ma'am. Affidavit of
Okay,
support.
that
Yeah,
would
there's a
be
whole
great.
bunch of forms. It's not. I've just mentioned a few of
Yeah.
them. But when you start reading these,
Uh-huh.
you should be able to figure out the rest of
Uh-huh.
them. Okay.
Okay. Okay, that's great. Thank
You're
you so much.
welcome. Good luck.
Appreciate it.
Bye
Thanks.
bye.
Bye bye.
Okay. If I say done, yeah. Okay. Let's go now to Connecticut. Give me a second. I'm trying to figure this out as I go along. Okay. All right, Connecticut. Go ahead, please, Connecticut. Connecticut. Your last four digits are 5035. Okay, I guess you can't hear me for some reason. Let me go to the New Jersey. What is the phone number? 5006 are the last four digits. Okay, New Jersey, go ahead, please.
Yeah, hello.
Yeah, New Jersey.
Yes, can you
I
hear
can
me?
hear you. Yes, ma'am.
Yes. So hi, my name is Neha. I have applied for I-131 form, and I have green card since May of 2015. Now I was in India for last 6 months. I have just come back in October, and I've applied for I-131 because for medical reasons I want to go back to India and stay there for up to 2 years. But my question was that is it a one-time re-entry permit, the I-131, or is it multiple times? So say for suppose some reason I have to come back in 4 months and I have to go back again for 2 years, do I have to again apply for the re-entry permit when I'm back in 4 months, or the permit that I have for 2 years is valid throughout the period?
Okay, ma'am. It's a multiple entry document.
It's a multiple entry,
Yes,
right?
ma'am.
And the fact that I have stayed for last 6 months outside of US in India, will that shorten my permit? Will I get a permit of less than 2 years, or it doesn't matter?
No. Look, green card is always tricky. I would advise you to take consultation with a lawyer. Make sure there are no other issues clouding your green card. But normally, a green card requires you to have permanent home in the United States. If you are gone for six,
Yes, I have a permanent home, and I have filed tax returns. I also had a job which I had to leave because I wanted to go for my treatment for last 6 months. So that's why I've left the job. So I can prove that I am staying here. My husband is also here. My home is
then
here.
you should be okay. Then I'm not concerned. You should get your
Right.
re-entry permit for 2 years. Yes, ma'am.
For 2 years, I should be able to get, and it's not a one-time thing, so I can come back and go as many times as
Yes, ma'am.
possible within the 2 years.
It's a multiple entry document,
Right.
unlimited entries and exits.
Right. So every time I come here, I have to present that re-entry permit,
Yes, you do.
or only. Yes, I have to present, even if it's under 4 months or
Yes.
8 months or
Yes.
whatever. Right. Correct. Okay. All right. Thank you very much.
Good luck.
Thank you.
Bye bye. Okay, let me go back to Connecticut because I think for some reason they couldn't hear me. Let's try again. Now your last four digits are 5035. Let's try again. Connecticut, can you hear me? Connecticut? Yes,
Hello?
sir.
Yeah, so I was speaking, I don't know, something was not working
No
fine.
problem.
But that's
No
fine.
problem.
Thanks,
Sure.
Rajiv. So I have a question regarding my wife. She's on H-1 visa beyond 6 years. Her I-140 is also approved, and her visa is now about to expire in March. So they were planning to file for extension.
Okay.
But in between, she got promotion 2 months back, and her title got changed to the lead position. No one reports to her actually. It's just their HR hierarchy. They got the next title as the lead position, so they gave her the that title. Her job duties are same. Everything
Okay,
else is same.
stop. Remember,
But
I've been saying
yeah,
from the very beginning that the I-140 regulations have been finalized.
right.
It's covered. This topic is covered under those regulations. So why don't you wait till Monday? I will be able to give you an exact answer. I'll actually, when I post, I'll remember you. Just look for my comments on my blog. I will remember you. I'm old, but I'm not that old. I will remember. So when you see my comments, I will have a comment specifically because what government said was in the proposed regulations, they said normal promotions we consider to be okay. We don't consider them to be a problem.
Right. The issue was like her attorney was not ready to file for extension. He was saying like your title needs to be changed back. It
No,
cannot have lead.
tell them to review most lawyers don't know yet because we just received an advance copy of the final rule. It's only going to be published tomorrow. So tomorrow everybody will know.
Okay.
Just tell them to read the new rules. Okay?
Sure, no problem.
You're
Thanks,
welcome.
Rajiv.
Good luck.
Thank you. Bye.
Bye bye. Okay. Now we go to New York. I always find it very amazing that we have people right now from Pennsylvania, New York, North Carolina, Kentucky, more New York, Maryland, Wisconsin, Michigan. It's just people from all over the country. Such a great feeling. Okay, now we go to, let's see, let's go to, what is this? This is New York. The last four digits are 4088. Okay, 4088. Go ahead, please.
Hi, can you
I
hear
can
me?
hear you just fine, ma'am. Go ahead, please.
Great. I have a question about affidavit of support and using the intending immigrant's income
Right.
if it's continuing from the same source, but the intending immigrant is not in America.
That's not required, ma'am. You can still use the income. I had a case, very interesting case recently. I'm trying to remember whether we used the intended immigrant's income. I think I used her assets. But the idea is, if you read the instructions on the Form I-864, they should make it clear that the assets don't have to be, or even the income doesn't have to be in the US, as long as it can be, you can give them a conversion figure of what the income is. And also remember, you can have a co-sponsor who doesn't have to be related to you. As long as they are a green card holder or US citizen, anybody can be a co-sponsor.
Right, but particularly I'm the spouse of the petitioner and the intending immigrant, and I can prove that the source would the income would continue from the same source, just that
Right.
I'm not in the U.S. right now.
Right. Well, that should be
And
okay.
my domicile.
That should be okay.
But it will be.
Ma'am, I want to point something out. I don't remember all the details of this law offhand, but I know that we've done this before and it worked out quite well, no problem at all. This was a guy in UK,
Okay.
and we used his income in UK to establish his ability to contribute towards his own upkeep.
Okay.
So it's done. I don't remember the details and what the contours and the limitations of this law are, but it is definitely allowed. You can look at USCIS website under affidavit of support and also State Department website. Okay.
Yeah, we have looked at it.
Yeah, I don't know the answer off the top of my head, unfortunately, but it should be.
Okay.
It can be done. I know that. Okay.
Okay.
Good luck.
Great. Thank
You're
you.
welcome. Bye-bye.
Thank you.
Okay, now we have 3 more questions left and then we are done. This one says unknown, so it must be a voice over IP. Go ahead if you're calling from Vonage or Skype. You logged in at.
Hello.
Yes,
Hello.
ma'am. Go ahead.
Hi, sir.
I have a question regarding
Yes,
I-130.
ma'am.
My father, he filed, like, my father is US citizen, he filed for my brother as a marriage last
Okay,
year.
ma'am. It couldn't be 140. You think 130, right? You're thinking 130.
Yeah, 130.
Okay, 130.
130.
Okay. All right.
But this year, his wife expired.
Yes.
So
He'll be considered single. He'll be considered single.
The now question is, because when we filed, we entered, his daughter also, because he has one daughter.
I still think that he would be considered single because I remember running into this issue before where somebody was divorced and then another time somebody was a wife died. We were able to file them as single despite them having kids, but I don't know how it would play out if it happens after you file. I think you can still contact USCIS and ask them to convert the case to a single child or single son.
Yes, sir. I did that. The question is now through 30, like I-130, but my question is, when the NVC send a visa, like issue a visa, would send for daughters or only for mothers?
Oh, okay. So your question is, would the daughter be included? If she's under 21, she'll be included now.
Because now they changed to the petition like a US citizen filing for unmarried son.
Yeah, but unmarried means somebody who's lost their spouse. And that's what I understand the law to be, ma'am. What you can do is, if you're unsure of it, of course you can talk with a lawyer, have them research this issue, but you could just as easily contact your congressman's office. Ask them for help on this, okay? That would be free of cost.
So here in my city, congressman?
Yes.
Okay, sir. And I have the same question, like, even I filed petition for my brother in 2008, and my father just asked you.
Well, hang on. Your filing will come through only in 2021, 13 years or so.
Yeah, that's too long. That's why, like, is there any way to expedite?
You can't. Not your case, no, ma'am.
Not even for my father.
You can't. There's no expediting of priority dates. The dates will move according to their own time.
Not even medical basis.
No basis.
My father
No,
is really.
the world could come apart. No. Okay, let's go on to New York and then Maryland, and then we are done. Okay, this is, let's see, New York. New York, go ahead, please. New York.
Hello.
Hello.
Can you hear me?
Can you
I
hear
can
me?
hear you. Yes, ma'am.
Yeah.
Yeah. Hi, this is Savita here. Actually, my husband already called that Connecticut line, but I just wanted to add something on it. Like, this is regarding this H-1 filing after promotion. So the promotion generally they said it is the team lead. That's the concern my lawyer, our company's lawyer raised. So just wanted to check. I know you said like we have to check the 140 thing which is coming tomorrow, but just for information, previously the
I think you're going to be okay. I'm not worried about you very much. Okay.
Oh, okay.
So even though the application developer team lead should be fine in that new 140 thing, that's what you're saying,
my
correct?
memory of that is that's what the I-140 proposed rule said. But let's just wait until I have them posted. And as I told your husband, I will remember. I will make sure I make a note for you there. Okay.
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 Sure.
Okay.
Good
Sure.
luck.
Thank you, then.
Thank you,
worry.
then. Thank you so much.
Don't worry. Okay, so the last call of the day is Maryland. Yes, Maryland, go ahead, please. Maryland.
Hello.
Yes.
This is Rama.
Yes, Brahma.
And I came,
I came here to US on entry visa and then have an H-1B and I need to go to stamping.
Yeah, I have answered your.
Hang
Hang on. Did you hear my answer? I already answered your question.
Okay, I think
I missed it.
No, you have to listen to the recording. I already answered your question. In brief, what I said was this. I said you can leave your spouse in USA while you go for visa stamping. It is okay. But if it is taking more than a couple of months, the spouse should come and join you in India.
And
another question is Mexico or Canada.
Well, the law is the same. No matter where you go, it's the same idea.
Okay,
Does it
matter? Okay.
I heard in some of the things like if I came from L2 and going to H1B stamping, I need to go to the home country only.
No, you can go to any country. It's called third country national processing, TCN processing. You can go to any consulate usually. Only sometimes if the consulate become very busy, they can stop taking TCNs, but normally they all take them. Okay?
Okay.
Good luck.
Thank you.
Okay, folks, as always, it's a great privilege to be talking with you, answering your questions. I will see you again in 2 weeks. Thank you for being here. Bye-bye. Every other Thursday at 12:30 p.m. Eastern Standard Time, we host free community conference calls. Everybody is welcome to join. Some people post questions ahead of time. You can take membership in our forums. All of the details are there on our website, immigration.com. You can take membership ahead of time, and it's instantaneous. It happens right away. And post your questions beforehand, or you can just log in. The phone number and all are provided: 202-800-8394, 12:30 Eastern Standard Time every other Thursday. We have free apps for both Apple iOS platform for your iPhones and iPads, as well as for Android. Just look for immigration.com, the period dot, and the application should show up.